This is going to be 9 minutes. This is going to be 9 minutes at 240 words a minute jury charge. 9 minutes at 240 words a minute. Ready? Members of the jury, in any jury trial there are in effect two judges. I am one of the judges, the other is the jury. It is my duty to preside over the trial and to decide what evidence is proper for your consideration. It is also my duty at the end of the trial to explain to you the rules of law that you must follow and apply in arriving at your verdict. First, I will give you some general instructions which apply in every case. For example, instructions about burden of proof and how to judge the believability of witnesses. Then I will give you some specific rules of law about this particular case. And finally, I will explain to you the procedures you should follow in your deliberations. You as jurors are the judges of the facts, but in determining what actually happened, that is, in reaching your decision as to the facts, it is your sworn duty to follow all of the rules as I explain them to you. You have no right to disregard or give special attention to any one instruction or to question the wisdom or correctness of any rule I may state to you. You must not substitute or follow your own notion or opinion as to what the law is or ought to be. It is your duty to apply the law as I explain it to you, regardless of the consequences. It is also your duty to base a verdict solely upon the evidence, without prejudice or sympathy. That was the promise you made and the oath you took before being accepted by the parties as jurors, and they have the right to expect nothing less. As I told you earlier, it is your duty to determine the facts. In so doing, you must consider only the evidence presented during the trial, including the sworn testimony of the witnesses and the exhibits. Remember that any statements, objections, or arguments made by the lawyers are not evidence. The function of the lawyers is to point out those things that are most significant or helpful to their side of the case, and in so doing to call your attention to the facts and inferences that might otherwise escape your notice. In the final analysis, however, it is your own recollection and interpretation of the evidence that controls in the case. What the lawyers say is not binding upon you. Also, do not assume from anything I may have done or said during the trial that I have any opinion concerning any of the issues in this case. Except for the instructions to you on the law, you should disregard anything I may have said during the trial in arriving at your own findings as to the verdicts. While you should consider only the evidence, you are permitted to draw such reasonable inferences from the testimony and exhibits as you feel are justified in the light of common experience. In other words, you may make deductions and reach conclusions which reason and common sense lead you to draw from the facts which have been established by the evidence. You do not be concerned about whether the evidence is direct evidence or circumstantial evidence. You should consider and weigh all of the evidence that was presented to you. The law does not require the prosecution to call as witnesses all persons who may have been present at any time or place involved in the case, or who may appear to have some knowledge of the matters in issue at this trial. Nor does the law require the prosecution to produce as exhibits all papers and things mentioned in the evidence. Certain charts and summaries have been admitted in evidence in order to summarize facts shown by documents and records which themselves are too voluminous to be conveniently examined in court. You should consider the evidence presented concerning the preparation and accuracy of these charts and summaries, to give each of them such weight as you believe it deserves. I have admitted the transcripts for the limited and secondary purpose of aiding you in following the content of the conversations as you listen to the tape recordings, and also to aid you in identifying the speakers. However, you are specifically instructed that whether the transcripts correctly or incorrectly reflect the content of the conversation or identify the speakers is entirely for you to determine based upon your own evaluation of the testimony you have heard concerning the preparation of the transcripts, and from your own examination of the transcripts in relation to your hearing of the tape recordings themselves as the primary evidence of their contents. If you should determine that the transcripts are in any respect incorrect and unreliable, you should disregard them to that extent. I remind you that it is your job to decide whether the government has proved the guilt of the defendant beyond a reasonable doubt. In doing so, you must consider all of the evidence. This does not mean, however, that you must accept all of the evidence as true or accurate. You are the sole judges of the credibility or believability of each witness and the weight to be given the witness's testimony. An important part of your job will be making judgments about the testimony of the witnesses, including the defendant, who testified in this case. You should decide whether you believe what each person had to say and how important that testimony was. In making that decision, I suggest you ask yourself a few questions. Did the person impress you as honest? Did the witness have any particular reason not to tell the truth? Did the witness have a personal interest in the outcome of the case? Did the witness have any relationship with either the government or the defense? Did the witness seem to have a good memory? Did the witness have the opportunity and ability to understand the questions clearly and answer them directly? Did the witness's testimony differ from the testimony of other witnesses? These are a few of the considerations that will help you determine the accuracy of what each witness said. In making up your mind and reaching a verdict, do not make any decision simply because there were more witnesses on one side than the other. Do not reach a conclusion on a particular point just because there were more witnesses testifying for one side on that point. Your job is to think about the testimony of what each witness said and what you have heard, and decide how much you believe of what each witness had to say. You have heard evidence that Joseph Green and James White have entered into plea agreements with the government. Their testimony was received in evidence and may be considered by you. You may give their testimony such weight as you think it deserves. Whether or not their testimony may have been influenced by their plea agreements is for you to determine. Their guilty pleas cannot, however, be considered by you as evidence of this defendant's guilt. The guilty pleas may be considered by you only for the purpose of determining how much, if at all,